the Supreme Court of Bangladesh was constitutionally entrusted with the protection of rights and liberties as a forum where people can access justice. Honorable participants, as we gather here today, first let us acknowledge the remarkable strides made by Nepal and Bhutan in shaping their constitutional frameworks and upholding democratic principles. The new constitution of Nepal was adopted in 2015. The constitution establishes that the Supreme Court of Nepal has the ultimate power to interpret the constitution. It has thus secured the freedom and liberty of the Nepalese people. Similarly, the 2008 Constitution of Bhutan placed the judiciary within the spectrum of democratic constitutional monarchy, magnificently reflecting the sacred principles of popular will. In the post-2008 and 2015 context, both Bhutan and Nepal's judiciaries have demonstrated their commitment to popular will. In the case of 2018, named as Srestha versus Office of the Prime Minister, the Supreme Court of Nepal issued a writ of mandamus and ordered the government of Nepal to pass and implement a new climate law to effectuate Nepal's commitments under the Paris Agreement and obligations under the Constitution. In Bhutan in 2010, the case named Opposition Party versus the Government of Bhutan, the court determined that the opposition party had standing to sue the government for alleged violation of separation of powers, and that taxation, appropriation, and budget actions all require tabling before both houses of the parliament. Esteemed colleagues and friends, with these considerations, now please let me turn to the Constitution of the People's Republic of Bangladesh, with provisions leading to equal opportunities for all citizens, prohibiting discrimination on arbitrary ground, the implementing affirmative action to support disadvantaged groups. The Supreme Law of Bangladesh acts as the authoritative source of fairness. In this regard, the Supreme Court of Bangladesh was constitutionally entrusted with the protection of rights and liberties as a forum where people can access justice. Historically, even during periods of extra-constitutional regime, in the late 70s and 80s, the Supreme Court remained in the service of the people. For example, in 1978, in the case of Haji Zainal Abidin versus State, the Supreme Court asserted that the Constitution was not subordinate to martial law rules and regulations. In line with this assertion, the Supreme Court subsequently held the martial law regime unconstitutional in the Fifth Amendment case in 2005. In 1989, in Anwar Hussain Chaudhary case, which is famously known as the Eighth Amendment case, the Supreme Court of Bangladesh maintained constitutional supremacy. It held that the amendment of the Constitution is subject to the retention of the basic structures. Reflecting on these judicial decisions, I am reminded of the delicate balance judges must maintain. While the Constitution is shaped through judicial interpretation, it is crucial to remember that our role is to elucidate the law, not to create and legislate it. Following the democratic transition in early 90s, Bangladesh started enjoying a new era of pro-people judgments. The Supreme Court of Bangladesh expanded the rules of standing, paving the way for public interest litigation to flourish. This court also extended its suo motu jurisdiction to address numerous social causes. Meanwhile, the judiciary had also secured its independence from the executive branch, upholding the principle of separation of powers enshrined in the Constitution. In 1999 Mazhar Hussain case, the court has clearly established the separation of judiciary from the executive, demonstrating its commitment to judicial independence and ensuring that justice is served without interference. Respected colleagues, the judiciary has also been a loyal advocate for social justice, addressing issues that often fall even within the private domain. For example, in Nelizaman versus Gasuddin Khan, the Supreme Court of Bangladesh declared that the practice of a husband's unilateral demand for restitution of conjugal rights was outdated and inconsistent with the concept of equality. This ruling depicts the court's understanding of gender justice to include equality. Similarly, the High Court's decision in 2020 of granting Hindu widows the right to inherit both agricultural and non-agricultural land owned by their deceased husbands marked a significant step towards removing discriminatory practices. Furthermore, the judiciary has also bridged legal cavities through incorporation of international laws when necessary. The historic judgment by our High Court Division in 2006 in State versus Muhammad Raushan Mandal case has profoundly influenced our legal system's approach to juvenile justice and thus ensured conformity with the UN Convention on the Rights of the Child. The court's dicta establishing a minimum age for children who come in conflict with the law, creating specialized children's courts, and treating these children in a rehabilitative manner, which were later incorporated in the Children Act 2013. Distinguished guests, access to justice is of fundamental importance, ensuring that everyone has the opportunity to seek legal remedies. However, like all rights, it must be balanced and not place excessive and unreasonable demands on the courts. This balance is crucial in maintaining a fair and efficient judicial system that can effectively serve the needs of the public. Currently, civil disputes are on the rise, leading to a significant backlog in the judiciary of Bangladesh. With 1.7 million pending civil litigations cases, the increase in civil litigation, including cases involving individual rights, property rights, and personal injuries, has been dramatic. Some argue that society has become excessively litigious, but I do not share this view. But it is essential that litigants are made aware of the downsides of litigation before becoming formally involved. Litigation should be a last resort when all other options have failed. Litigants' trust and confidence in the judiciary of Bangladesh in turn bolsters the ability of our judges to handle litigation satisfactorily. I am sure our honorable guests from abroad will find interesting relevance to what I have described right now. These facts may at least show that some of the immense burdens faced by my colleagues from Nepal and Bhutan are common to my brother judges in Bangladesh. So, each of our judiciaries must remain vigilant in protecting the rule of law and be prepared to take additional responsibilities in the pursuit of justice. If judges do not step up to those responsibilities first, no one else will. It is important to remember that there are many ways to resolve disputes. In particular, ADR can often provide a satisfactory remedy, and where possible, such remedies should be accepted. Bangladesh has made significant legislative efforts to promote ADR, including the Arbitration Act 2001 and ADR provisions in the Code of Civil Procedure 1908 and the Money Loan Courts Act 2003. Despite these efforts, ADR has not gained widespread popularity due to the lack of uniform guidelines, proper training, and public awareness. To address these issues, the Legal Aid Act was amended in 2006 to include ADR as a legal aid service. In 2015, the post of District Legal Aid Office was established to resolve disputes outside the courts through ADR. Legal aid officers, all being judicial officers, are empowered to conduct mediation, making the process more accessible and potentially increasing ADR success rates. These initiatives aim to reduce the backlog of cases and bring positive changes to our legal landscape by establishing a well-functioning ADR mechanism integrated into the legal aid system. Respected colleagues, in this connection, the existing arrangements for legal aid in Bangladesh hold significant relevance. The Constitution of Bangladesh requires the state to ensure that all citizens have access to a comprehensive legal aid scheme through legislative measures. The National Legal Aid Services Organization is a statutory body responsible for formulating policies and implementing, monitoring, and evaluating legal aid programs throughout the country. This institutional approach ensures that justice is not only a theoretical ideal, but a practical reality for all citizens. Ladies and gentlemen, allow me to draw your attention to another important issue. As stewards of our planet, we cannot afford to overlook the interconnection of our actions and their far-reaching consequences. The adverse effects of climate change, worsened by various factors, threaten not only the fragile ecosystems of our respective region, but also the livelihoods and well-beings of our people. Our collective landscapes bear witness to alarming shifts in weather patterns, the depletion of natural resources, and increasing volatility in river systems due to rapid meltdown of Himalayan glaciers. Yet, in the face of these challenges, we also possess the opportunity to bring forward meaningful change through judicial cooperation. In 2019, the Supreme Court of Bangladesh, in the case of HRPB versus Bangladesh, declared that all rivers in Bangladesh are to be granted the status of legal persons. Similar to natural persons, this status provides rivers with fundamental rights with legal protections. The court also issued a series of directives aimed at protecting these rivers from encroachment. In Nepal, in the case of 2021, known as Shailendra Ambedkar versus Office of Prime Minister, the Constitutional Bench of Supreme Court of Nepal held that although it is the authority of the executive agencies to make decisions regarding the sale and export of riverine materials, this cannot be done in a reckless manner, destroying the biodiversity and ecosystem of an area of huge environmental significance. State agencies cannot become the cause of natural and environmental destruction of the country. As children of art, we must acknowledge that every human being has the right to life, right to live in a habitable environment, and after all, right to present their children a better art. This acknowledgement is, in today's context, one of the most important dimensions of fairness that we are now concerned of, that we all dream of. Through collaboration, we can harness our collective strengths to preserve our shared heritage and protect the pristine beauty of the Himalayas for generations to come. Let us stand united in our commitment to safeguarding our environment and securing a sustainable future for all. Together, let us forge a path towards a brighter and greener tomorrow.